Adrianne Lynch with the Lynch team at Real Broker, and today I have Heather Parker with me from the Parker Law Office. What are conversations that family members should be having with, if it's their parents or their elderly, to make sure they don't have to go through probate? Like, what is it? Is it the steps to say we don't want to have to drag something out for a year, take on those expenses? So what should they be saying, or questions they should be asking?
So, I mean, honestly, it often starts first with, what is probate? I think a lot of people don't. They'll ask me, what does that actually mean? So a probate is really a court case, and it's the state's way of overseeing the distribution of someone's assets once they've passed. So if you think about all the things that might be in the name of the person who passed, that's got to be managed by somebody if that person isn't here anymore. So you think about bank accounts and property and cars and stuff and all the things that just an average person has. If it was in their name when they passed away and they didn't have beneficiaries named on those assets, that if the value of those assets exceeds $75,000 in Arizona, is going to require a probate case. And like I said, that the court wants to oversee and make sure that those assets ultimately go to whoever the proper heirs are. They also want to make sure that the right person is in charge of distributing those assets. So whether it's the fact that somebody has a will in place, and that's sort of a side myth. A lot of people think that, well, if I have a will, then I'm never going to have to worry about a probate case. And that's absolutely incorrect. The courts have to review and make sure that the wills are proper. They're the original, they're correct, current, and so that has to be submitted to the court. That's part of the probate case. Now, if there's no will, then there's still a probate case. So either way, if you've got assets that are over $75,000, we're looking at a probate case. So what do we look at to decide, how do we avoid that mess, right? If we don't want to do that, which I think most people don't, how do we get away from dealing with that or having our family members have to deal with it? And there's a couple of paths for that. One is make sure there's beneficiaries named on those assets. There's very little in the state of Arizona that you can't name a beneficiary for. So think about, like we said, the basics. Most people are familiar with a life insurance policy. You can name a beneficiary on that, but you can do it on lots of other things too. Investment accounts, retirement accounts, bank accounts. So a lot of times the financial institutions will refer to that term as TOD, which is transfer on death, or POD, which is pay on death, but it all means the same thing as beneficiary. And all that means is, this is where I want this asset to go when I'm gone. That's the quick and dirty version of it. Right. You can even do that with real estate in Arizona. There's something called the beneficiary deed. So I can create a deed that says, this is where I want my property to go when I'm gone. You can even do that with a vehicle in Arizona. ADOT has a beneficiary form. You can name beneficiaries on vehicles as well. So about the only thing you can't do that on is personal property. You know, I don't know a lot of people who have $75,000 worth of personal property. I mean, I guess you could, depends on what sort of collections you might have. But if you think about your things, your stuff, that's what we talk about when we're talking about personal property. So jewelry and artwork and furniture and, you know, just our stuff. Those are things that can be done. Another tool that a lot of folks will use is a trust. So that is essentially creating a set of instructions about how you want your assets to be managed, not only at your passing, but also at a time that you might be incapacitated. And so there can be some real big benefits to having things being directed by a trust. And the way that happens is you actually retitle your assets into the name of the trust. That's what gives those instructions the power that it gives. And sort of the side benefit to that is the fact that then there's no need for a probate case, because if I've retitled my assets into the name of my trust, now when I pass away, I don't own $75,000 worth of assets. It's all in the name of my trust, and my trust doesn't die. So we can avoid probate cases that way as well.
We will have Heather's information below so that you can reach out to her for a consult. And if you have any questions, she's the one to talk with.